Uh, Good afternoon. Before we call the case, I'll mention a couple of things. One, to the attorneys, well, we appreciate your agreeing to participate in this oral argument by Zoom. It keeps the court's cases from getting backed up, and it moves them on towards disposing of them for the parties. If we should have any technological problems, we'll just take a pause, and Mr. Hivner and our IT people at the AOC will resolve it. Sure. Call the case, please, Mr. Hivner.
Sarah Perkins Chambers versus Joshua Timothy Chambers.
We'll hear from the appellant.
Your Honor, good afternoon. I'm Jerry Becker from the Knox County Bar on behalf of Sarah Chambers. Briefly, Your Honor, I would like to state a timeline for the court in its consideration of this case. In August of 2016, these parties followed a parenting schedule that was ultimately signed off by the court on January 5th, 2017. And in that permanent parenting plan, the mother was the primary residential parent and was allotted 225 days. The father had 140 days. On December the 7th, 2017, the divorce, the final judgment was entered. The parties had been following the permanent parenting plan for approximately 16 months. In December of 2017, Ms. Chambers moved to Knox County, and in 2008, at that time, made new friends, was involved in extracurricular activities, and was involved in preschool education. Your Honor, in January 22, 2019, the mother filed a motion to enforce the marital dissolution agreement because of various financial matters that had not been resolved by the father in terms of what he owed the mother pursuant to the MDA. And then after she filed that motion to enforce the marital dissolution agreement, in June 19, 2019, he filed a petition to modify the primary residential parent plan and the co-parenting schedule. I think that it's important that the court see the considerations of time that have gone on since August of 2016, and it wasn't until the father was served with papers about enforcing the MDA that all of a sudden he files this petition to modify the parenting plan. Court goes back and looks at that petition. The court's going to find that there was nothing stated in that petition that would give rise for consideration by this court of changing anything really in that petition. The allegation was a bare allegation that substantial and material change in circumstances had occurred such that the primary residential responsibility should be changed to the father. The petition then on to say that the mother had moved more than 50 miles away from the defendant, and that as a result that she failed to comply with the TCA. They didn't even identify the TCA statute, and it failed to notify the father and the court of the move. And then went on to say an allegation that the child's complete extended family, both maternal and paternal, lived in Sevier County, and that the minor child's association with children and adults were all within Sevier County. The court, and that's the sum and substance of this petition. It is our position, Your Honor, that there is nothing that was either contained in the petition or at the hearing that would give rise to any change in the permanent parenting plan, let alone who was the primary residential parent. There were no factual allegations raised that would show that there was a substantial and material change of circumstances whatsoever. The only issue that they raised had to do with the 50-mile designation. Your Honor, as I will say in a few moments about that issue, in addition, that was the only issue of substance that was raised in these pleadings. The court will find that there were no factual allegations as to material change of circumstances. There were no factual allegations as to any harmful effect upon the child. There was no factual allegations that the permanent parenting plan started by the parties in 2016 was unworkable and was not in the child's best interest. The sum and substance, Your Honor, is that there were no prima facie claim presented to the court, which would have allowed the court to rule at all and change the parenting schedule. By the way, the court kept Ms. Chambers as the primary residential parent, but they changed the schedule. Now, with respect to the issue of the 50-mile rule, Your Honor, the rule should be designated or read on a radial basis level. And that's what the court did in Massey Holt versus Holt. The court stated in its decision that with respect to the mother's move, in that case, to Maury County, it was well within the allowed mileage radius. And the move necessitated the change of school enrollment. The court was on to say if father's argument regarding joint educational decisions was accepted, it would essentially result in a vast de facto tightening of the restrictions on divorced parents' freedom of movement, contravening the legislature's intent in allowing essentially unfettered relocation within, at that point, was a 100-mile radius. Your Honor, we introduced as an exhibit the Google map, which showed that it was 39.04 miles from the father's residence to the mother's new residence. It was clearly within the 50-mile radius. And I think it's important that the court will come down and say it is the radial distance which is the determinative factor as to the 50 miles. It's not to be based upon driving distance. In this case, both parties submitted driving distance measurements. And in fact, the trial court said, if I have one driving distance that's below 50 miles, that's enough. I'm not going to find that this part of the statute is applicable. Well, the fact of the matter is the mother showed that her driving mileage was under 50 miles. The father showed that his was over 50 miles. And that's the problem that you have if you take driving distance. That should not be the way that this 50-mile rule is read. It should be read as the court in Massey Holt did, based upon a radial measurement from the two houses. And on that basis, we asked that the court find that there was no need to apply the 50-mile an allegation that the 50-mile limit had been violated, because in fact it had not. The only proof was that the radial distance was 39.04 miles.
Mr. Becker.
Once you get past the
Mr.
issue
Becker.
involving, yes,
Mr. Becker, assuming that we agree with
yes,
you
sir.
on assuming for the sake of argument that we agree with you on the 50-mile radius, what about the other changes in circumstances? Are they considered?
Well, Your Honor, I'm getting to that. As the court knows, that when the court goes on determination of material change of circumstance, that it's a two-step process. And the court, I think the cases have held that, and I'm reciting now to case of Ambrister versus Ambrister. The question is a two-step analysis there for request for a modification of primary residential parent and modification of residential parent schedule. The threshold question always is, Your Honor, whether the material change of circumstance has occurred. And the court differentiates the question of primary residential parent designation and changing the schedule. With respect to finding that there was a material change of circumstance for the residential parent to be modified, there must be some sort of failure to adhere to the parenting plan. If they're asking for a modification of the parenting schedule, then the question becomes, is it in the child's best interest? And in that respect, the issue is, was the parenting plan unworkable? Your Honor, there were no allegations whatsoever that the parenting plan was unworkable at all. It simply that is a statement by the father that the child is now back and the child should go to a school which he didn't even talk about in his pleadings, but at the hearing, a school that that he felt was accommodating the distances between the two parties, and that was King's Academy. There were no allegations of anything being unworkable about that parenting plan, and consequently, they did not meet the prima facie case that this court requires. There be some proof of the parenting plan in the first place, and then in the second place, the court has to make an analysis of whether any proposed new plan would be in the child's best interest. What we say to the court was that there was no proof of that whatsoever. The trial court simply just said, well, the child's going to go to King's Academy. There was no proof as to why it was in the child's best interest to go to that private school as opposed to going to the school that she was registered to go to in Knox County, which was the Hardin Valley Elementary School.
Mr. Becker, let me ask, Mr. Becker, excuse me.
Yes.
Did anybody bring up, how did the King's Academy, how did it get brought up?
It was brought up sua sponte in the trial. The recommendation by the father was that the child would go to King's Academy because it was a very good private Christian. And the judge said, well, I know about King's Academy and I know it's a good school. And the father said, I'll pay for it. And then the judge said, well, okay, if the father will pay for it, we'll have the child go to King's Academy. That was the sum and substance of the hearing and the testimony and the judge's finding. And in the Pierce case, the Court of Appeals said, trial court can't do that. The trial court can't just substitute its feeling about a school and derogate the joint decision making that the parties have about education. The court could not take judicial notice and how that's private school being in the best interest of this child, period. The long and short of it is that, as the court has said, existing custody arrangements are favored since children thrive in stable environments. A custody decision once made and implemented is considered res judicata upon the facts in existence on those which were reasonably foreseeable when the decision was made. It's our position that this child was thriving underneath the parenting plan entered into by the parties in 2016. She was involved in preschool. She was involved in extracurricular activities. She had blended well with her new siblings as a result of her mother marrying, and both parents have remarried. And so, for the reasons that I have just articulated, Your Honor, this court should overrule the decision of the trial court. The trial court should not have gone beyond the issue involving the relocation statute, and once it went beyond that, there was no finding by the court, no allegations pled that the parenting plan was not in the child's best interest and workable by the parties. And for those reasons, we ask the court to set aside the decision of the trial court, remand this matter back to the trial court for entry of an order that substitutes or puts back in place the original parenting plan agreed to by the parties in 2016.
Thank you, Mr. Becker. You have your time for rebuttal. We'll hear from the appellee now.
Hello, may it please the court. I'm Felicia White, and I represent the appellee, Joshua Chambers. While there were a lot of different pleadings that were filed before the court, this appeal really centers around the father's request for a modification of the parenting plan. After the court heard proof on that issue, the court found that a modification of that plan was warranted, and then the mother then appealed. The mother in her brief or in this appeal raised 4 issues, the first of which was that the court erred in determining that she had moved outside of the 50-mile radius in violation of the relocation statute in TCA 366108.
What did the court use to determine the mileage?
What did the court, I'm sorry.
What was presented to the court to determine the actual mileage?
There was a Google map that was presented originally by the mother that then was entered as an exhibit by the father that showed 3 different distances. That showed a 52.1 mile distance, a 51.8 mile distance, and then again a 52.1 mile distance. The father then testified that he had in fact driven that route and how he had driven it, and that it took the 51.8 miles for him to drive from his residence to the mother's residence. The mother then testified that there was a different route that could have been taken, that her testimony was that it took her 49 miles. There was a Google map that was presented that at that time I think was marked Exhibit 2, that seemed to, by the testimony, be the same route that was contained in the Exhibit 1, but that mileage was different. The mileage in the Exhibit 1 was the 51.8 miles, and even though it was, by the testimony, the same route, the mother's map, I think, was then the 49 miles. So,
I'm sorry, either within the last week or the last 2 weeks, we released an opinion, and I cannot remember the style of it, that concerned whether or not, in that case, whether or not the trial court could take judicial notice of a Google map for distance purposes. Or either of y'all, or Mr. Becker, you can answer this when you get back on rebuttal, but Ms. White, have you seen that case, that opinion?
I have not. I have
like
not.
that. It's very, very recent. So it addresses perhaps some of this, what we talked about in that case. But neither here nor there. So the trial court had before it, as far as driving distances, some said it was over 50 miles. At least one said it was under 50 miles. And then did it have a radial distance between the two places?
Well, again, the father testified that he himself had driven it and he had himself clocked it, and it had been the 51.8 miles.
Yeah, but was the trial court presented any evidence from the Google map or otherwise that from point to point, straight line, not driving, that was within 50 miles?
That seemed to be more addressed when the court heard the motion to alter or amend filed by the mother. And that's when I think that it was more clearly presented by the mother that the court should look at that by the radial miles or a direct line rather than how they would be driving. And the trial court then asked, when they were referring to the Massey Holt case, was this a new case that had come out since the original trial? And was this new evidence that was just discovered? So the court then determined that it had heard all of this proof before, and that based on, I guess, the ruling in Massey versus Holt, that it was not clear to the court that they should be calculating it by the radial mile rather than by the driving distance. So the court declined to alter or amend that previous ruling. It would be our position that the Massey Holt court did not say, in fact, that the court, or the distance, I'm sorry, should be calculated by the radial mile. What that court said was that the mother had only moved, I believe, 35 miles, and that was not beyond the 100-mile radius or the 100 mileage radius. They did not say that that was supposed to be calculated by this direct line as a crow flies. So it would be our position that just because they use that word 100-mile radius, that does not mean that that should be calculated by a direct line. Someone cannot travel by a direct line. So when we're looking at, legislative intent, it would have to be that the court was looking at parents then exchanging a child and the distance that it would take a parent to travel in order to exchange that child. Well, they cannot travel as the crow flies. They have to travel by road. So the only way that it seems logical to calculate that would be the actual driving distance rather than this direct line approach. However, and I guess more importantly, though, the court said, which brings me to the second issue that was raised, that it wasn't just basing the finding that there had been a change of circumstances on the fact that it had ruled that mother had moved beyond this 50 miles. It specifically said that there were additional findings and additional reasons that the court had found that there was this change of circumstances, such as the child had aged from, I think, 2 to 5. The child was getting ready to start school, that both of the parents had remarried, and the child was bonded with siblings and step siblings in the home, and the effects that that new distance would have on the interactions with both sets of grandparents, which both still reside in Sevier County. So it wasn't just the fact that the court found that she had moved beyond this 50 miles, that it was determined that there had been a change of circumstances, and then the court ruled that there was reason to modify and that a modification was in the best interest. And as Mr. Becker pointed out, it is a very low threshold when the court is modifying a residential schedule rather than the primary residential parent. The court did not modify the primary residential parent. Mother was primary residential parent in the original parenting plan. Mother remained primary residential parent. And I pointed out in my brief that the court heard a very similar issue in the In re Jesslyn C case, which is a 2015 Court of Appeals case. And in that case, the Court of Appeals found that the trial court did not err in finding that there had been a change of circumstances because the child had matured from 2 to 5 and was now starting school. So that case is very, very similar to this. So we would ask that this court find, the same as was found in that In re Jesselyn C, that there was no error in the court determining that there was a change of circumstances that warranted a modification of the parenting schedule. Then the third issue that was raised by the mother was that the court erred in ruling that the child would attend the King's Academy, and in doing so, inappropriately took judicial notice of the school. The father had, in his initial petition to modify, requested that the court make a determination on where the child was to attend school. So that issue was before the court. The court did, in fact, during the father's testimony, say the court is familiar with the King's Academy and that the King's Academy was a good quality private school. However, that was not an issue that was before the court. There wasn't a dispute over whether the King's Academy was a good school or a bad school, or whether the King's Academy was better than Hardin Valley or better than Sevierville. That was not an issue that was before the court. So in order for the court's statement to have been improper, that had to have been an issue that potentially was in dispute, and it wasn't. The father testified that the reason that he was proposing the King's Academy was that it was equal distance between the two parties' residence. That the mother lived in the Hardin Valley area, which is where she was proposing that the child go to school. Father lived in Sevierville. He testified that Sevierville Primary would actually be the closer school to him, much closer to him, but that the King's Academy in Seymour would be equal distance between the parties. It was based on that the court ruled that the child would attend the King's Academy, not because the court had some sort of prior knowledge that the King's Academy was a great school. The court went on to talk about, in its ruling, the stability that they were trying to achieve in dividing that drive time for the parents, and that all of the burden wouldn't be on one parent, but that burden would then be divided between the two. So I think that for the court to have found that that was an improper statement that it would have had to have been an issue that was in dispute, and it wasn't. Which brings us to the last issue, which was that the court erred in making the ruling, or in ruling that the child should attend King's Academy because the parties had joint decision making. Well, as I said, the father requested in his petition to modify that the court make a determination of the child's school. When the court ruled that there had been a change of circumstances and then ordered that the party exercise a week on, week off, or something similar to a week on, week off parenting schedule, the court then had to determine where the child was going to go to school. These parties live a distance apart. The father testified that it took him an hour to get from his home to the residence, or to the mother's residence. The father was never asking that the court change the designation from joint decision makers to a sole decision maker. The father was merely asking that the court make a decision on where the child should go to school because the parties were unable to make that decision together. Mother testified she wanted the child to go to Hardin Valley schools. Father testified, while he was closer to Sevier County, that he wanted the child to attend the King's Academy. So it's clear from the record that there was no agreement on where the child should attend school. And when there is no agreement, then the court has to be the tiebreaker. And that doesn't mean that the parties from that point forward don't still have joint decision making. But when a joint decision cannot be reached, there has to be some way of then deciding what happens next, which is for the court to then make that determination. So in the court being that tiebreaker, the court found that there would be more stability and continuity if the child would attend the King's Academy. And while that did put more of the driving burden on the mother than she would have if the child was attending Hardin Valley, that more split the burden between the parties. And that was what was in the best interest of the child. So it's our position that there was no error made by the trial court in any of the 4 issues that were raised by the mother, and we would ask that the ruling be upheld.
Thank you. Mr. Becker, we'll hear from you in rebuttal.
Yes, Your Honor. It's incomprehensible that Ms. White would not answer the court's question as to the issue involving the radial distance. I believe that case you referred to was Total Garage Store LLC versus Nicholas C. Moody. And in that case, I understand that the court said that the court approved the trial court's taking judicial notice of Google Maps. The fact of the matter is that Massey Holt talks about radial distance, and that's what it has to be from point A to point B. And Exhibit 1 in the trial, Exhibit 1 was the Google map showing point A to point B being 39.04 miles. Ms. White has intentionally or otherwise tried to confuse this court to look at it only on the basis of driving distance. That's not what this is about. And the Google map referred to clearly had under 50 miles. Secondly, the judge said during the trial, if one of you have it below 50 miles, that's enough for me. The relocation statute doesn't come into play. And it was shown that the driving distance the mother had was below 50, but he still disregarded. The fact of the matter is that there are burdens that have to be met by anybody trying to overturn a permanent parenting plan. And the biggest burden is material change of circumstance. It was not pled factually, it was not proven factually, and as such, the court cannot become an arbiter, decide which school a kid goes to, simply because the parties may disagree about that. There has to be a burden that the father had to meet. He did not meet it pleadings, he did not meet it at proof, and the court had a chance upon the motion to dismiss, and then upon the Rule 59 motion, to clear that error, and for some reason, it did not. We asked the court to set aside the judge's ruling and to order the permanent parenting plan that was in effect in 2016 to be re-implemented between these parties. Thank you, Your Honor.
Thanks to counsel for both sides. We appreciate your arguments and your briefs in this matter. Mr. Hebner, if you'll recess court until our next case this afternoon.
This
you.
honorable court is now in recess until 3:30 p.m.
Thank you.